Good evening, everyone. We will start in 1 or 2 minutes. Good evening, everybody, and welcome to Planning for the Future of Your Loved One with Special Needs. My name is Wynn Everts, and I'm the Executive Director of the ARC Connecticut, and I'm really happy to host this session. We're going to cover a lot of ground tonight. We've got 2 excellent presenters, but just let me explain the ground rules of what's going to happen tonight. You'll all be muted throughout the presentation, but you have the ability to ask questions by using the chat function in Zoom. You can find the chat function in a menu bar that's along the bottom of your screen. It's in the center of your screen, and you can type your question in chat. And the presenters may answer the question as it becomes relevant to what they're talking about. At the end of the speaker time for the presenters, if there are questions left over, I will ask those questions to the presenter. So we'll try and get everybody's question answered by the time we reach our hard stop time of 7:30. If you want your question answered, let me tell you the areas that this session's focusing in on, and that those will be most likely to get answered. It's special needs trusts, the new ABLE Act, protecting government benefit eligibility, guardianship and conservatorship, SSI, SSDI, Medicare and Medicaid, financial security and funding options, and letters of intent. The email that Shannon sent to all of you with the link also has some additional information at the bottom that may prove useful to you. I wanted to point that out to you. And so without any more delay, it's my pleasure to introduce our presenters. Attorney Colleen Masse is the Special Needs Planning Department Chair at the law firms Czepiga, Daly, Pope, and Perri. Her practice focuses on planning for both elders and persons with special needs of all ages. In addition, we have Stuart Hawkins from FutturesPlanned. Stuart has been a financial advisor for nearly 30 years with a concentration in special needs planning for 15 of those years. But more importantly, Stuart is the proud parent of a young adult with special challenges. So with no further delay, Stuart and Colleen, the floor is yours, and thank you for being with us.
Thank you, Wynn. Thank you, Shannon, for having us. Let me get this here. So what keeps us up at night? As families that have loved ones with special needs, we have a lot going on in our lives. So it's easy to put off doing this type of planning. Inevitably, what people say, what really keeps them up at night is the question of what's going to happen to my child when I'm no longer here. It's understandable that it's not easy to do this planning, but it's vitally important. Many folks have not planned sufficiently. And again, it's not that they don't love their children, it's just that there's so much going on in their life. It's hard to plan for tomorrow when we're overwhelmed with what's going on in our lives today. And how do we know if we plan sufficiently? A little quiz here. Are you certain your loved one will be able to earn a living sufficient enough to support themselves without your continued assistance?
Excuse me, Stuart. Yeah. Stuart, I'm just going to interrupt you for a second. The PowerPoint is not on the screen.
It's not. There now?
There it is. Perfect.
Okay. Go through all this stuff. Okay, are you confident government benefits will support your loved one in a manner that is acceptable to you? Do you have a special needs trust set up to preserve government benefits? And is it sufficiently funded? Have you planned on how you're going to fund it? Have you identified a care provider for your child? And do you have a written letter of intent that caregivers can follow? And the last one is a catch-all. You believe you've done everything possible. So if you find tonight that there are areas that you have not planned, it's okay. Everything can be fixed because we're all still here. It's only when we're no longer here that things become permanent. So special needs estate planning is very different than the financial planning or estate planning that typical families employ, both from a legal as well as a financial perspective. Now, somebody once told me that there was 3 types of attorneys. There's the attorney that you go to that says, I really am not an expert in this area, but I'm going to refer you to somebody who is. And we have one of those on our presentation night tonight with Colleen. The third type of attorney is the one that you go to says, I'm not really familiar with this, but I will figure it out for you. And they use you as a guinea pig. And that's really not the type of an attorney that you want to use to do this type of planning. That can be said true for the financial side. There's a lot of intricacies to this that your typical lawyers and financial advisors are just not up to speed on. So it's important to work with a team that knows what they're doing in this area. So we're going to talk about the legal side of things. We're going to talk about wills. We're going to talk about the special needs trust. Well, mostly Colleen's going to be talking about that. And then we're going to touch on guardianship and conservatorship. Colleen, it's all you.
Sure, thank you. And I do want to reiterate what Stuart was saying. I'll often have someone come into my office and they'll have a special needs trust, and I'm putting air quotes on that, that their grandmother had drafted for their child. Very thoughtful, very forward thinking of the grandmother. However, it was drafted by a real estate attorney or something of that nature, and it just doesn't work. So then we're scrambling. So it is important to have the right advice. And additionally, it's really important to have the right financial advice as well. We work very closely with financial advisors. A lot of the interaction between my work and the work that Stuart does it does have an intersection, and it's really helpful to have both people on the team. So a will really just deals with anything that is in your own name with no beneficiary upon your passing. And a lot of people, especially if they're married, when they sit down and they think about what is in my own name that doesn't have a beneficiary on it, there's not usually a lot, right? If you're a married couple, a lot of things are in joint names, a lot of things are in both names, a lot of big assets, retirement accounts have beneficiaries on them. But the will does serve some really important roles, right? One of them is it's a place that you can list a guardian for a minor child. So that's super important. And it's really important to a lot of our families. And honestly, it's the reason a lot of families don't come to do their will, because they can't think of who their guardian is. So we say, well, sometimes you want to start with who is not going to be the guardian, right? Who don't I want to take care of my child? Let's start there. And then it also dictates where any of those solely owned assets go. And if you haven't dictated that, the state of Connecticut dictates it for you. And we run into a lot of trouble with that, right? We have someone pass away and they don't have children, their assets go to their siblings, someone has a disability, it messes with their benefits, all of that. So it's really important that you have a will. And here are some of the things that people find surprising a little bit. So the second one I think is particularly surprising. If you have a spouse and descendants from you and the spouse gets the first $100,000 and half the balance, but your descendants inherit the rest. And people might not think of that. They might assume everything is going to their spouse, but it doesn't, because the intestacy statute lays it out exactly how things go. So things aren't always exactly the way you imagine, and they certainly may not be the way you want them to. And if you're planning with someone that has any kind of government benefits, this certainly won't serve your needs.
Absolutely, the starting point is having a will so that assets are directed where they need to go. So $1,600. This is, if we had audience participation, this is where I'd be asking people if they know what the significance of this number is. And the answer is you can't have more than $1,600 in an individual's name, and you're ineligible for most government benefits if you're over that amount. And actually for Social Security, it's $2,000. Other states mirror the Social Security, but in Connecticut, the number is simply $1,600. And that number is, it's not that the state is discriminating against our children with special needs. That's the same Medicaid number for somebody who is going to go into a nursing home as a single individual. They can't have more than $1,600 in their name. So the issue we have now is we have a child with special needs. We know we want to leave them money, but we can't leave them money directly because of this rule. So what is one to do? And that is where the Special Needs Trust comes into play.
Right, so a special needs trust is a place that you can park money for the benefit of your loved one, and it doesn't interfere with their benefits. So the really important thing, like Stuart mentioned, is that $1,600 for Medicaid and the $2,000 for SSI, for supplemental security income. We don't want to have our children miss out or our loved ones miss out on these benefits. We've done the math, and there's, $800,000 or something like that of benefits of SSI over a lifetime. The individual monthly amounts seem meager, but when you think about it over a lifetime, it really adds up. And then Medicaid is just a huge benefit, because there's a lot of programming through Medicaid, which you don't want to miss out on. And some of that programming just isn't offered anywhere else, right? Sometimes the housing options or the day program options just aren't even offered privately. So you really do need to have that Medicaid eligibility. So a special needs trust allows you to leave money for your loved one for their benefit, for them to have a better quality of life, but not to interfere with them having these options for their government benefits.
Right. I just wanted to point one thing out, because I always like to during one of my presentations on SSI, Supplemental Security Income. You should be receiving $783 a month prior to any reduction for employment. If anybody is not getting $783, say they're getting $522, that's a 1/3 reduction. There are ways to fix that, and I just want people to be aware of that. So special needs really is a spectrum, from those with special challenges to higher functioning individuals, all the way to very profoundly disabled people. And sometimes a question is asked, what if my child isn't going to receive benefits? Government benefits. And the question is, does a special needs trust still apply here? And Colleen, do you want to speak to that?
Sure, because it's more than just the benefits, right? So we have a lot of people use trust for a variety of different reasons. And what the additional safety that the special needs trust can offer, and Stuart and I have a board member we were both on Plan of Connecticut with, and he would say predators, creditors, and divorce, right? So when this money is insulated in a special needs trust, even if the benefits aren't necessary, it's not going to hurt someone to have someone looking out for them and to have some additional protection. If they really don't need the special needs trust because of benefits, then their trustee can know that. They have sole and absolute discretion, and they can make distributions more freely. But it does allow for the option, if the trust is needed, to have that in place. If the trust, and Stuart can really speak to this being on at the board at plan, which we'll discuss a little more as we go along. But if there's someone that, if the trust isn't necessarily needed to protect benefits, then there's a lot more freedom for the trustee to be able to distribute. So there's no harm in having the trust in place.
I'll go through this, Colleen, you can jump in. There are essentially two types of special needs trusts that we need to concern ourselves with, and it's really a question of whose assets are going to fund the trust. There's a third party and a first party trust. And a third party trust, that money's usually coming from parents or grandparents, someone other than the person with special needs. And the first party trust, just as it sounds, it's the special needs individual's own money. Now, why would they have money in their name? Could be from back Social Security payments, could be from a lawsuit. But most commonly, it's because there's an inheritance. Somebody left them money. Now, are there restrictions on how this money can be used? In a third party trust, there's language that says it's intended to supplement, not supplant, any government benefits that the individual is eligible for today or in the future. And in the first party trust, there's language that's for benefit only. Now, what does that mean? What that means is that that money can only be used exclusively for that individual. So to illustrate that, let's say Johnny wants to have a birthday party and he wants to have his friends go out for pizza and a movie. Can Johnny's first party special needs trust pay for that? And the answer is no, it cannot. Why? Because other people are eating the pizza. Sounds ridiculous, but that is the rules that you have to live by. And you'll see why in a second. Now, the question here, who gets the remaining assets when our loved one passes away? In a third party trust, it's your choice. It could go to their siblings. It could go to a charity. It could go to the Arc of Connecticut. You wouldn't ask me to say that. So now, who do we think gets the assets in the first party trust when all's said and done? It's the state. That's who cares that other people are eating the pizza. Okay? The state is the first in line beneficiary for whatever is left in the trust when the individual passes.
I just want to do one small clarification, Stuart, because absolutely your pizza example is perfectly on point, and we have that all the time, and I know that you see it all the time as well, with people asking for a party. It was clarified a couple of years ago by Social Security that they're not being as strict about sole benefit. They have backed up a little bit, and they're now calling it primary benefit. People used to think that it was so extreme that if you lived in group housing, no one could sit in the chair or look at the TV, or, everybody had to have their own little mini fridge. That has been eased back. So it now is primary benefit, but ultimately it is the same restriction that it can't be for other people. A lot of clients want to buy something for grandchildren or something like that. You can't do that with a D4A trust, a first party trust. So I just wanted to clarify that. And I think a question came up about SSDI, and I'll just quickly, that's a different benefit that we're not really addressing today. That is based on the work record, either your own work record before you became disabled or a parent's work record, a parent that's now retired or disabled. That does not have those asset tests that we talked about for SSI and for Medicaid. So it's a little bit different program, a lot more flexible. I'm sorry to interrupt, Stuart.
No problem. So I like to call the first party special needs trust the whoops trust. Okay, whoops, we did not do the planning ahead of time. unless it's a lawsuit, a medical malpractice lawsuit, or I've seen numerous times now, somebody got bit by a dog and they get awarded $40,000. You cannot put that money into a third-party special needs trust. It has to go into a first-party special needs trust. But certainly in inheritance, if we did the proper planning, if we did the proactive planning and set up the third-party trust, then we don't have to worry. The inheritance goes there. Grandma, grandpa, us as parents, it goes there. The first party trust, I like to say, is reactive planning. Whoops, somebody died, left the child money. They're going to get kicked off of benefits. What do we have to do? We have to go to Colleen. Colleen has to set up a special needs trust, and the state is the primary beneficiary. So that's not ideal. Okay. You can have both, but you want to plan to have the third party trust.
100%. And we see it all the time that people, like I said, they died without a will, or someone well-meaning left money to a grandchild thinking that it would really make their life better. And oftentimes it becomes quite cumbersome to work out exactly how to handle it. And it can be costly, can take time, stress, and effort. And that's certainly not what the person that left that money for that person had ever intended.
Okay, so what can we use to fund the special needs trust? You can use just about anything from property, investments, retirement funds, and life insurance. The most important thing I want to point out here today is the trust does not need to be funded today. Many people get caught up with, well, I don't have a whole bunch of money that I can put into this trust today. It's really not about funding it today, and most third-party special needs trusts are not funded until the passing of the parents. Think of it just as the vessel that any money that we would want to leave our child with special needs, that's where it goes. If we have 2 children, we can leave to the typical child outright their inheritance. Our child with special needs, it goes to their third party special needs trust. Now, what can we use to fund it? Property, your house. Yes, you can leave the house to the special needs trust, but we don't really consider that an asset. Nobody lives in their house for free. Even if there's no mortgage on it, there's still taxes, maintenance, upkeep. So what the trust actually wants is investable assets that can generate a rate of return that can supplement any government benefits that the child is receiving. Retirement funds can be left there, yes. 401k, IRAs, but you have to remember if you had $100,000 in a retirement fund, unless it's a Roth, you're going to have to pay taxes on it. So it's not truly $100,000. And we hope that we as parents are going to be using our own retirement assets, but in the end, ultimately, it could go towards the trust. And the last one is life insurance. And life insurance is a very common tool that we use in special needs planning to make sure there's going to be money left over in the end. And in order to understand that, really need to understand life insurance. And there's really 2 broad categories. There's term and there's permanent insurance. Term insurance covers you for a period of time. It can be 10 years, 15, 20, 30 years, age dependent. You can't get a 30-year term policy if you're 60 years old. Employer paid group insurance. Most of us have, or many of us have, term insurance through work. It's provided by our employer. What's common about all of these is it provides coverage if you die. It's just like any other insurance that we have. We don't ever want to use it. We don't want to say, thank God I had fire insurance on my house because my house burned down. We don't want to say, thank God I had term insurance because it's likely that you died young with term insurance. Permanent insurance, on the other hand, properly designed and funded properly, is supposed to last your lifetime. Comes in different varieties: universal life, index, variable life, and what some people call the whole category, whole life. What's common about them, again, properly designed and funded, provides coverage for when we die. And when you have a child with special needs and you're planning for 2 generations and you know you want to leave money at the end, it just makes sense that this fits into the financial picture. It's really not as much about insurance, because if you think about it, insurance is really all an if proposition. And unfortunately, mortality is 100%. The insurance industry did a study on that and they couldn't believe that it was 100%. They turned around, they did another one and it came back the same. We all are going to pass away at some point. So that's why it really fits into this planning well. And last bit on insurance, what's very common in our world of special needs is using what's called a second to die or survivorship policy. It covers both parents and pays at the second death. And generally because you're doing that, it costs less. When do we need the trust funded? As we spoke about before, it's when the second parent passes. We don't need it funded while we as parents are alive. So how much do we need to fund the trust with? That is a very difficult question, and there is no one right answer to that. It really depends on the assumptions you're going to make on government benefits. Are they going to be there? Are they going to meet my child's needs? Once we do fund the trust, it really needs to be invested more conservatively. We can't take a small amount of money and buy penny stocks and lose it all, because it's likely the last money that's going to be there for the child. And whenever possible, we want to err on the side of more rather than less. And why do I say that? Because it's not an asset that is wasted. It's not going to go back to the government. We get to name where that money goes when we're no longer here. So if we have extra amount at the end, it's going to go to where we designate it to go. And last thing I want to point out, this was right out of DDS transition planning, and this happened, I don't know how many years ago. It all blends together for me, 4 or 5 years ago, where they cut the budget for students transitioning out of high school, out of their school systems. And there was going to be no day programs for those folks. And if it weren't for the ARC of Connecticut and concerned parents that went down to the legislature, they got the funding put back in. So these benefits are not guaranteed. They're not a law. It's a budget thing. So, want to add anything to that, Colleen?
Yeah, I just like to echo what Stuart says. You know, a lot we'll have families and they want to know how much they should put into the trust, and really it's a family decision. But I will say that our firm does act as trustee for some people, and the way we approach this situation is we say, you know, whatever you feel comfortable that you can leave to your child, however you can fund it, you work with a financial person. But when we're the trustee, what we do is we work with a financial projection, right? So you've put X amount in this trust, you're X years old, and we look at how long, if the money grows, we want to make sure the money lasts your lifetime. And then we come up with a budget based on the amount of money that we have, with budget projections and your life expectancy. So the more that's in that trust, the more that's going to be available to your loved one. I did have a family member that had $100,000 that she had received as an inheritance. She decided she wanted to give it to her loved one that had a disability and put it in a trust for him. So we did come up with a budget for how much we can use, how much can be spent, and it's still going to improve his life. $100,000 improves someone's life. You know, so it's not, there's never an amount that's too small. But I do think that if you have the flexibility to leave extra to someone that has a disability, it really will allow the flexibility to the trustee and to make sure that it can be used as best possible to improve that person's life. So I agree.
Speaking as somebody who acts as a trustee through Plan of Connecticut, which I'm going to talk a little bit more in a second, but it is so much easier to make decisions on distributions out of a trust if there's plenty of money in there. It's really heart-wrenching when you as a trustee have to make a decision on spending money, knowing that there's a very good possibility that that money's not going to last the individual's lifetime. And the question is, what's going to happen when it runs out? So that's why I always say more is better than less. You do what you can. So what is the role of the trustee? Colleen? You're muted.
I'm muted. So I am working in my house. My refrigerator is just a little bit over, and there are people at the microwave having dinner right now. So I thought I would spare you all the beeping. So if I forget my mute again, just let me know. So I act as, at our firm, we act as trustee, and Stuart at Plan of Connecticut acts as trustee. So we both have experience dealing with these kind of issues and what's important as a trustee. But I always say the first thing you want is someone that you trust, right? You want to have a trustee that you trust. That's number one. But the trustee has a variety of jobs. One of their jobs is to make sure that the assets are managed appropriately, right? To be using an appropriate financial advisor to make sure that their money is invested, to make sure that it's growing and is going to last for the person's life. They have to file tax returns for the trust annually, right? And again, we don't do that. We hire someone to do that. I know at Plan of Connecticut, where Stuart is, they also hire someone to do that. You have to understand public benefits. So these are decisions we make every day, like Stuart was talking about. We have someone on SSI, they have a small trust. We want to make sure we're using their trust in a way that doesn't interfere with their SSI, because they can't afford to lose a third of their SSI every month. If we have someone with an $8 million trust, maybe we're not as worried about losing that third a month. Maybe we're going to be more comfortable spending money on their food and lodging. So we need to understand their benefits and make sure that we're making wise choices. Sometimes you may choose to forego benefits, but you don't want to do it by accident. You want to do it thoughtfully. You make appropriate distributions from the trust, right? So you get bills, you pay them directly, you don't give money directly to the person that has the disability, the beneficiary of the trust. The money doesn't go to that person directly. And you have to be appropriate about the distributions. You have a budget typically. Like I said, we lay out the next 20 years and what's our monthly budget? And those are when we run into those hard questions Stuart was mentioning, right? So we have our monthly budget. It's $500 a month. That's our budget. But the van, just like the transmission is gone and our person can't get anywhere now. So now what do? We say, sorry, no van for you? Probably not, right? We're probably going to dip into the trust and make sure that the person can get where they need to go. Just had someone with a new wheelchair that was too big for the door to their house. Say, no, sorry, your trust can't pay to make your door bigger so you can get in and out of the house. Of course you have to. So these are decisions that you have to make, and you have to always be thinking about the benefits, the amount that's in the trust, and making decisions that are in the best interest of your beneficiary. And then you need to carry out the wishes of the grantor. And so part of that, and that's the person that set up the trust, right? So we ask a lot of questions, and we use a letter of intent. I know Stuart uses one. We're going to talk about it. What's your trust for? Why did you set this up? Did you set it up because you really believe in education and you want to make sure your loved one has a good education? Do you want to make sure they have access to travel? They love to travel. Is religion important to you and you want them to be able to make some kind of special journey or pilgrimage? So these are all really important things, and we want to know what the person is leaving the money for. What are their goals as well? Stuart, do you have anything to add on the trustee role?
No, we'll talk a little bit more about trustee. Well, the next slide. Who can serve as trustee?
Yeah. So I always put it in 3 buckets, and I always say we have the bucket, the family friend member bucket, right? I refer to it generically as Uncle Bob. Occasionally I'll have a client that really does have an Uncle Bob, and we all laugh about that. The nonprofit, you have an Uncle Bob? Maybe he's a good trustee. I don't know. He probably loves you and will meet you at Best Buy if you need a new TV. He might not understand benefits, but he can hire someone that understands benefits, right? So that's, he's a good option maybe. There's the nonprofit plan, right? And Stuart's going to talk more about them. And the reason Stuart and I the reason I keep referring to them with Stuart is that's where I met Stuart. We met at Plan. So we have a little bit of history there. So they're a nonprofit. They do a wonderful job. I always say the executive director there is one of the smartest people I know. So they really do a nice job. Or you can choose.
What about the board chair?
The board chair is okay. We could talk more about that over a glass of wine.
Yeah.
And then you could choose. So obviously the board chair is Stuart. And then the other option is someone that's a professional trustee. And I have my own bias against banks. There have been some issues with some banks. So if you are considering a bank, you really want to make sure they're a bank that knows special needs trusts. There have been issues in both directions with banks. So we at our firm specifically had a client that had $1 million in a trust. The bank didn't know anything about benefits. And by the time the bank decided to hand off the trust to a successor, which was us, the person had depleted their trust to $250,000. And a lot of that was on things that benefits might have paid for. And then there's the other extreme with the bank, which is the bank is so concerned about investing money, right? Their goal is more money that they don't make any distributions. So if you're considering a bank, I would really inquire as to what their experience is with these kind of trusts, because they are different. And then you can use an attorney, right? But again, I would ask that the person does this kind of work. Go ahead, Stuart.
Yeah, the last one again, Plan. That's where I met Colleen. I've been involved with them for, I don't know how many years now, probably 10. And the chairman of the board for probably 5 now. And it's a wonderful organization. It's where I learned many of the things that I know about special needs just by being a trustee, sitting in meetings on a monthly basis, making decisions, very, very hard decisions sometimes on how to spend money. But it's a not-for-profit that's overseen by the state of Connecticut banking department. Have about, I don't know, pushing 15 employees now, and you have a trust administrator who becomes familiar with the beneficiary. I think it's a great organization for those who really don't have other options. Perhaps they don't have siblings, they don't have that Uncle Bob, and they want to do it efficiently and with people that know what they're doing, and an organization that doesn't have a life expectancy. These are all reasons why you might want to use a non-family member. If you're going to name your sibling, they're about your age, you know, and you may want to name your child's sibling, but then again, do you want them to have to deal with all the things that a trustee has to deal with, or do you just want them to be there to support their sibling? So these are all
and I also just want to add that Plan of Connecticut has one of the things that people don't always know is they have what's called a charitable trust. So if you are in need of something, and anyone, and again, Stuart makes these decisions, so be nice to him, but if you have a disability and you live in Connecticut, you could be eligible for a distribution from their charitable trust. The information is on the website. When I was there, it was one of the things I was trying to get the word out for, but people, all kinds of things, laptops or ramps to get access to their home, or, upgrading a van or something like that. So
helping to pay for a wheelchair accessible van.
Yeah, absolutely. But they were finite things. That's the thing. It can't be like your monthly cable bill, right? It's going to be something finite, a one-time thing. But they have this resource, and it's not widely known. So I try to sing it from the mountaintop as much as I can.
So what is the ABLE Act? It's relatively new. First accounts were opened back in 2016. So we're coming up on, I think we're right now, I think it was actually June. We are coming up on 4 years right now. So what an ABLE account is it's similar to a 529 college savings plan. It allows individuals that have special needs to put money away above and beyond that $1,600 amount. It kind of makes it invisible, that money. You can contribute up to $15,000 a year into it. Connecticut does not have one right now, but I want to stress that you do not have to wait till Connecticut has one. I was on a Zoom meeting with a client today, and she hasn't done some of the things that she needs to do. And she said one of them is an ABLE account. And her concern was, well, Connecticut doesn't have one, so she can't walk into a bank and open one up. And I explained to her that even if Connecticut had one, you would not walk into a bank and open one up. It's all done online. So it doesn't really matter that Connecticut has one or doesn't have one. You can use other states. My daughter's is set up in Ohio simply because they were the first. Those are my two go-tos are Ohio and Massachusetts. Massachusetts for smaller amounts of money because they do not have an annual fee on theirs. However, their investment expenses are quite a bit higher than Ohio. Ohio, you're paying, I think, $35, $40 a year to have the account open. So if you're only going to put $200 in, it's kind of expensive to have that fee come out. But if it's going to be a couple thousand, it may be worth it. I know Ohio, you can call them and ask them questions, and they answer those very quickly. Now, my too good to be true slide. There are rules. Once $100,000 is reached in the account, SSI payments cease. The individual has to be, the disability had to occur prior to age 26, which for most of our folks here is not an issue. But the last one is the real kicker. There's payback, just like that first party trust. If there's any money left over in the account upon the passing, then that goes to the state. Now, you can pay for a funeral and other outstanding qualified disability expenses before the state gets paid back. So what I generally recommend folks do is don't put more than you would put into a funeral into one of these. I wouldn't recommend my client put $50,000 in here. That money is much better going to the third party special needs trust where we can determine where it goes.
Stuart?
Yeah.
There's a question on the chat that's related to this. Can a working disabled individual contribute more than $15,000 annually?
They can. I think it's like $12,000, $13,000 more that they can put in. But again, I don't know that I would recommend them putting all that money in there. For a parent to put 15 in and then the individual put more in, you're going to bump up against the 100,000. Although if that person is working, likely it's a whole nother topic, but likely they would be on Social Security disability, and that's not the same program as SSI, so that 100,000 wouldn't apply, but there's still payback for any Medicaid services provided to the individual.
And not to muddy the waters too much, but although federal law does allow the D4A to have federal payback, and that's what we've seen, although that we haven't seen much since it's only from 2016, not a lot of people have passed away with these yet. Some states have said that they will not seek payback. So I know Oregon, for instance, has said, even though we are allowed to seek payback, we will not. So Connecticut, the chances that Connecticut is not going to try to get their money back, I don't think they're very good. but hope springs eternal. So just something to keep in mind.
And we have a question on plan. If you already have a special needs trust, can you use plan? If you already have your privately written special needs trust and you name Uncle Bob as the trustee, you cannot just simply change that to Plan of Connecticut. Plan of Connecticut has their own trust document that's been approved by the Attorney General of the state of Connecticut. So in order for Plan to take over as a successor trustee, Plan would have to look at that trust and determine whether they can abide by the rules of the trust. And it would have to go out to legal counsel for them to look at and to make that determination. So it's not just a matter of saying that I want Plan to be the trustee. It would be a matter of actually using a Plan trust document, which somebody like Colleen would get as a professional member of Plan and fill in the blanks. And then Plan has, well, I'm not going to get into that now because we'll talk about that in a minute.
The other thing is too, I just had a client who had had a trust. Her sister was going to be the trustee for her son. And she said she didn't feel comfortable with that anymore. And she said that I saw Stuart Hawkins speak and he talked about Plan of Connecticut. And what do you think of them as an option? So I said, they're a great option. The trust was not funded yet. So we changed all of her documents. Instead of saying that her son was going to have a special drafted special needs trust, you know, from our firm, we're setting it up at Plan. We're changing her documents to now have her son have a Plan of Connecticut trust. So that's because the trust wasn't funded yet, though. Once it is funded, like Stuart said, they're going to send it to outside counsel and make sure that they can abide by the trust terms. But if it's not funded yet, sure, you can switch, you can change your mind about a trustee.
So you, Colleen.
All right, so this is a hot topic lately. People are talking a lot about, you know, substitute decision-making. This was really hot in the middle of COVID because people are saying, who can make decisions for me? Who can make decisions for my loved one? Who can make decisions for that individual? So there's a gamut of decision-making options. There are the option that we all should have if you do not have this in place, this is your homework for tonight, is to make sure that you and everyone over your household has a power of attorney in place and a healthcare document in place. Everyone should have this. It allows someone to help you by making legal, financial, or healthcare decisions when you either can't because of inconvenience or you can't because you're incapacitated. So it's really important. And our loved ones that have disabilities can have those documents too, as long as they can understand what a legal decision is, who they trust to make a legal decision for them, and as long as they can communicate that, they can have those documents in place as well. And alternatively for healthcare, what a healthcare decision is, who they want to be able to help them, or who would make those decisions if they can't, and be able to communicate those things. So this is really, that's the least restrictive. Typically in the past, and we're really kind of having a seismic shift, most families have gone the guardianship or conservatorship way. And these are court proceedings. You go into court, and if your loved one, the individual, has an IQ under 70, they can be appointed a guardian. That's for their personal needs, their living, their education, their medical, any of those kind of decision making. If they need financial decision making as well, then they would have to have a conservator of estate. So that would be if someone had an IQ of under 70. If someone does not have an IQ of under 70, they don't have guardianship as an option, but they can have a conservatorship if that's necessary. There's the least restrictive kind of conservatorship is a voluntary conservatorship. It means the person goes into court and says, I volunteer to have a conservator. I really want someone to watch out for me. I just inherited a bunch of money and I know people have taken advantage of me in the past. I want my mom to help me and be my conservator. So that's a voluntary conservator. The really nice thing about that is it gives that person the autonomy at any point to write a letter to the court and say, I don't want that conservator anymore. And the court will terminate the conservatorship within 30 days, unless the parent shows up in court and says, wait, I have a good reason that we shouldn't do this. I have a client right now who was, had much more difficulties, some mental health issues, and is doing much better now. And he and his family all agree he doesn't need that anymore. So he's getting that letter into the probate court and having that terminated. And he has that power, which is really, I don't know, to me, it's very important. Then there's the involuntary conservatorship, where the person doesn't have the capacity or the willingness potentially to say, I want to have a conservator, right? They may say very clearly, I don't want to have a conservator, but the court still might look at all the facts and say, you know what, this person needs help with their decision making. And we don't think that they should be able to bind contracts, and they should be making decisions for themselves because they're not making safe decisions.
Colleen,
Yeah.
You said go to court. That sounds scary.
So I don't know how many of you all have been through the special education system, but it's less scary than a PPT, in my opinion, right? PPTs, when I went to them, I always cried. Probate court, the judges are nice. It's a conference room, typically. It's not, maybe one or two in the state are actually in a courtroom, but typically it's a conference room. And typically the judge is dressed, like Stuart or I. They're not dressed in a robe, they're not dressed scary, and they deal with families all day. So they're familiar with the issues surrounding families, and they're familiar with, all of the different things that go along with that. So probate court is not terribly scary. I always over-prepare for probate court as an attorney because you never know what you're going to walk into. But as a family, they're generally very good-natured. I did want to also mention, right now, they're really, what people are talking a lot more about is supported decision-making. And I think of that as the way we all live. Again, so many things for individuals with disabilities have these special names, right? But they're just the way we've all always lived, right? If I have a medical question, I have somebody I ask. If I have an education question, I have somebody I ask. If I have a legal question, I have somebody I ask. Why can't people with disabilities also have this team in place? Why, if they need a team, are they all of a sudden not competent to make any decisions? So supported decision-making allows them to assemble this team. You probably should have a power of attorney and healthcare document as part of that plan, but it also means people are sitting down together and they're assembling their team of advisors. Maybe there's a vocational advisor or assistive technology advisor, right? Who's going to be their advisor? But they, again, just like with the power of attorney and the healthcare document, they keep the rights and the control, and they have the final word. When you're conserved or you have a guardianship, you lose the rights and control, and someone else has the final word. So that's really the distinction I make along that, that kind of spectrum of decision making.
Beautiful. Letter of intent. What is a letter of intent? It's essentially a blueprint of your child's life. Anything you would want somebody to know about your child, you can put in a letter of intent. It can be called different things, but they all boil down to the same thing. It could be a personal care plan or life care plan. It really is about what you want for your child. And you think about everything that we know as parents. If we weren't here tomorrow, what would we want that person to know? And that all is put into the letter of intent. To give you an example from Plan of Connecticut, we have a client where it's written out that it's very important for the individual to go to Cape Cod every summer because that's what the family did. And that is written down in there. So when we as trustees look at a request for a vacation to Cape Cod, we know that that's what the parents wanted. Anything from your medical information, medical history, hopes, dreams and wishes for your child can be put in the letter of intent. No letter of intent is the same, one person to the other. They're all personalized. I do have a template I can get you to help you start it. It's not an easy process, but it's vitally important so that the trustee knows what was important to you as a parent. Anything you want to add to that, Colleen?
I will say that we strongly encourage these whenever we draft a special needs trust, and we do have a booklet that we send out to everyone that does set up a special needs trust. We don't require someone to have it filled out in order to come in and execute their documents. But I do believe that these are really important. And I've started actually having workshops in the office where people come into the conference room and families can sit around and brainstorm a little bit, because sometimes it helps to get your ideas flowing. Well, what do you think? What do you think? Oh, yeah, that's right. When you said that, it reminded me my loved one needs such and such. So I agree 100% that it's really important for a trustee to have this. I also think that there's something I've been calling like a weekend letter too. That's also really just the bare bones again, this was more of a COVID thing, but just a bare bones kind of, where does my child go during the day? What do they eat? Those kind of things, just in case something were to happen to you and someone needed to kind of jump in right away, that needed the bare bones and the immediate, what needs to be known right away.
Shannon, some of these questions I think we'll get to at the end, if that's okay. Shannon? Okay. What do I need to know about beneficiary designations? Well, Colleen touched upon this earlier, but you can go to Colleen. Colleen can set up all the legal documents, your will, your special needs trust, and you have all of that done. But your retirement plan, 401k, IRA, annuities, investment accounts with payment on death provisions, and life insurance, all of those assets do not pass through your will. They pass by beneficiary designation. So once you've completed the legal work, we have to turn around and change all those beneficiaries to make sure that the assets that we intend to go to the special needs trust are actually going to go to the trust. Very, very important. A lot of folks fail at this. They do the legal work and then they forget that they need to go back and change contingent or secondary beneficiary on their life insurance. They could have life insurance that they're leaving to their spouse, but a lot of times what we do is we just say children equally. That could be a designation on a 401k, children equally. We can't do that anymore. We have to say 50% to Johnny and 50% to Mary's special needs trust. There's specific language that we have to spell out within the beneficiary designation.
And these are, and I'll just add, these are tricky, and these are the loose ends at our firm that we really try to wrap up, right? We provide people all the language. We say we'll contact their retirement plan, we'll do whatever we can for them. But we really love when there's a financial person involved that can help with this stuff and make sure that it's all gotten done. Because we see it all the time. People come in and they don't know who their beneficiary designations are. And there have been some recent changes to the law that's surrounding where IRAs, how they get distributed and all. And it's more important than ever to have those drafted appropriately. So I agree 100%. And I think that, this is a really great spot for the marriage of the financial advisor and the attorney to work together.
Okay, we're coming to the end here. So how do we coordinate our plans with other family members? Colleen, you can speak to this. You've done this, I don't know, millions of times where you set up, typically a grandparent isn't going to leave assets to their in-law, or AKA the outlaw. They're going to bypass in other words, if one parent passes away, the grandparents from that side are not going to leave the money to their daughter-in-law or son-in-law. It's going to flow down to their bloodline, and therefore it's going to flow directly to the individual, and that's a problem.
Yeah, so typically I've seen very few times where something was left to a daughter or son-in-law. So typically, I have 2 sons, so I would typically say to my sons, and then people use this language per stirpes, which means if one of my sons has tragically passed before me, any share that would go to him goes instead to his children. Very rarely would I see if my son had passed before me, it goes to their spouse. That's highly unusual. So what happens is that people have this filtering down through the generations, or they don't have a will at all, as Stuart had pointed out earlier, and money ends up in the hands of someone that it's become more of a hassle for than a benefit for. I had one client that said, "Can I just give the money to the state?" I said, "No, you can't give the money to the state. Your brother has intellectual disability, and the probate court is not going to allow you to give money away that could have gone for his benefit to the state." They said, "Well, we just don't want to deal with all the process." So there's a lot to be done. So one of the things we always provide when we do a special needs planning for a family is we provide like a letter to the family, essentially, which I always tell our clients they can hand them out to their family at the 4th of July picnic if they were such a thing. And the letter says, "If you're thinking of leaving any funds to my son, John, this is the language you should use. If you're putting in a life insurance policy, if you're putting it in your last will and testament, whatever it is, if you're going to an estate planning attorney, bring this letter with you." And it says the name of the special needs trust that you've set up, and it has all that information so that they can leave it to that person in an appropriate way so it goes directly to the trust. So that's really a very important piece of our planning, is we provide these letters to give out to family and friends and make sure that people are aware, if they're leaving something to my son, this is the way they should be leaving it. Because otherwise it could, as Stuart said here in his slide, it could sabotage the plan that people have worked on.
So we're at the end.
Look at that.
So how do we start this whole planning process? I know you guys are all very knowledgeable now because Colleen and I did such a wonderful job. Good job, Colleen.
Hey.
And you're all really enthusiastic. If I was in front of you right now, I could see it in your face. You're all smiling and enthusiastic. But I can tell you that knowledge and enthusiasm without action is really, it just flutters away. It goes away. So if you want our help, I'm available. I will meet with you. I do not charge consultation fees for meeting with people and looking at what they have and providing advice. So with that, Colleen, you can talk about your process and then
you're also welcome to drop me a quick email or call me. My email, I think you all got a handout that my firm provided. My email is colleen@ctseniorlaw.com. The number at the firm is 860-236-7673, and you can call. If it's a quick question, I'm happy to spend a few minutes on the phone with you and decide if you need to have a consultation. We do have a consultation fee, but if you tell the people scheduling that you attended a Zoom seminar, there will be a discount. But we'd be happy to meet with you and see what we can do to help. Stuart, you want to start going through some of the questions?
Yeah.
I already have them in order for you.
Oh, you do? Okay, perfect.
So here we go. We're going to go back to the discussion about special needs trusts, and one of the viewers, participants asked, is the state getting more aggressive in claiming money from special needs trusts more now than in the past?
So as we discussed, there's 2 kinds of special needs trusts, right? There's the third-party special needs trust. If that's drafted appropriately, someone else's money went straight into the trust, the state should have no interest in that. They should have no bearing on that. The first-party trusts, they don't typically go after it during the person's life, but upon passing, it's your obligation to reach out to the state, find out if there is any, we request a statement of assistance from the state, and they provide it to you. And if there's if there's bills due back, you have to provide them. If you've passed away, they will be notified by the probate court.
I can tell you at Plan, we send a lot of money to the state of Connecticut.
Yeah.
Second question related to special needs trusts. Is an irrevocable trust the same thing as a special needs trust?
There's a lot of different kinds of trusts, and special needs trusts can be either revocable or irrevocable. So you couldn't say that they're the same thing. No, there's a lot of different kinds of trusts for different kinds of purposes.
Thank you very much. Can you give examples of what qualify as disability-related expenses, I think in the context of ABLE accounts?
Yeah, the ABLE account. If you call Ohio up, the stable people in Ohio, they will tell you just about anything is going to qualify. The IRS is the regs say housing expenses, medical expenses, educational expenses, transportation expenses. But the big question that people will ask is, can it pay for a vacation? And I've asked that question of the people in Ohio, and they said, absolutely. There is a catch-all that says anything to promote the health and wellness of the individual. And I can make the argument that a trip to Disney World is promoting the health and wellness of the individual. So you would have to find some extreme examples where it wouldn't apply. You can't be giving it away. That would not be acceptable. But if it is being used for the benefit of that individual, then it should be fine. From purchasing of a car, transportation, you name it, living expenses, education, medical, are all going to qualify.
I agree.
My daughter uses hers. She has a debit card. She can go to Starbucks and get a coffee with her debit card.
Yeah.
We bought a computer for her out of her ABLE account. So just things like that.
I agree, and people are using them in interesting ways too, because, and we didn't get too much into the SSI and all of the different things that it can be used for, and the reduction, like Stuart alluded to, of a third. But you can move your money from a special needs trust to an ABLE account and then use your ABLE account to pay for your housing, and you don't get the reduction of by a third. There are some really interesting ways to use your ABLE accounts now. So people are getting creative.
So let's extend that a little bit further. Can you prepay funeral expenses from an ABLE account, and does that count as an asset for entitlement tests?
You can have a prepaid funeral contract that does not count as an asset up to certain limits, and I don't know what those are. Colleen, you may remember them. I don't.
Yeah, it's like 10,000 in your irrevocable funeral contract and any amount in your revocable funeral contract. What I tell people to say when they go is just say, I need this to be Medicaid compliant. The funeral people know what that means. You can really spend any amount on your funeral. It just has to be written up correctly in the contract. So you just tell the funeral person you want it to be Medicaid compliant, and there's really almost no limit.
So I wouldn't try to pre-fund out of an ABLE account, because that is an exempt asset. I would keep that separate. Put money in an ABLE account for ABLE purposes. And I likely, it depends on people's personal view, but I would think it would make more sense to put money in the ABLE account, use it for the benefit of the loved one, and then have the remaining assets go to pay the funeral versus pre-funding a funeral. That's just my personal opinion. People have different opinions on that.
But you want to prepay the funeral, because the bottom line is, at the end of your life and your ABLE account goes back, or your first party trust money goes back, and we've seen this happen. Now here's the family, that money is frozen, and the family has to pay for a funeral, and the money The money in that account goes back to the state.
You can pay for a funeral out of the ABLE account.
After the person has passed, Stuart?
Yes, yes.
Okay, because a first party trust you can't. First party trust you
No,
can't, but an
yeah,
ABLE account you
an
can.
ABLE
Okay.
account, you can pay for a funeral out of that prior to the state.
Perfect.
Can an aunt or an uncle direct a contribution into the stable account?
Yeah, absolutely. You can only have one account, but an aunt or an uncle, as long as it's not more than the $15,000. And this is another good point here. Grandparents that might be helping fund 529 college savings plans for all of their children. They couldn't do it for their grandchild with special needs. Now they can. They can simply make that contribution to the 529A ABLE account.
Okay. This is a question concerning Plan of Connecticut. What happens if an individual is all set up with Plan of Connecticut and then the beneficiary of that document needs to move from the state of Connecticut?
We have beneficiaries all over the country now. For that very reason, people have moved.
Thank you. Another question that I received was, for the contingent benefit designation, should it be left to the family trust or to the special needs trust?
Depends on your goals, right? I mean, I think contingent beneficiary designations, and it depends on what kind of a document you have, if it's an IRA or a 401k. Those are very tricky right now. If you leave it directly to a trust, it only gets 5 years of stretch. So the stretch means that you can take money over time to lower your income tax burden. If you leave a 401k or an IRA directly to a trust and not to a human, then you only get 5 years of stretch. If you leave it to a human in care of a trustee, then you can get more of a stretch. So there would be a lot to consider about what kind of account it is, what your goals are. If the person does have a disability, there are some special exemptions with the new Secure Act and the way the IRA stretch is working. So there would be a more complicated question than that, unfortunately.
One of the caveats to the Secure Act is that whereas your typical individuals can no longer do what's called a stretch IRA concept, where you can take distributions over the individual's life expectancy. We can no longer do that for typical people, but somebody with a disability, that's an exemption. So it elicits a unique planning opportunity for families that have children with special needs, whereas before we might say that it makes more sense to leave a retirement plan to typical families, typical individuals. Now that could be upended and changed, where it might make more sense to leave retirement assets to be able to do that stretch.
For sure. And we're definitely doing that kind of planning right now. We've had to modify our special needs trusts in order to make sure that they comply with the new Secure Act too. It just got dropped on us all in December, and we've been kind of waiting for some regulations. I don't know if we'll get any or not on the specifics, but it's changed the way people are doing retirement planning.
I'm going to paraphrase a question that was asked, which I think is a really great question. Can you each describe separately for your different professions why somebody would want to talk to a financial planner versus why somebody would want to talk to an attorney? What, different subjects, different problems, etc.
You need to talk to both, not one or the other. It's both. Anytime I'm meeting with a client, there is an attorney is going to ultimately be involved unless they already have an established trust that I've taken a peek at, and generally I can know if it's an attorney that I'm familiar with, I know that it's likely going to have been done correctly. If I've never heard of the individual, then it's a concern, and I'll have an attorney take a look at any legal document. But it's absolutely both. I don't have any of my clients just come and meet with me without, and actually go through my whole process without an attorney being ultimately involved in drafting documents, because it is a comprehensive, everything needs to be done correctly. It's not just attorney or financial advisor. Sorry, Colleen, you can go.
No, I agree. I think that, you know, the financial advisor is going to help you make sure that you have appropriate assets to leave, and make sure that you are comfortable with the way your retirement is set up for yourself, and that you're comfortable with 2-generation planning and all of that. Discuss all the different options for life insurance and all those things. And then the attorney is going to draft the documents that are going to direct all of the finances. So the two things go together.
Like I said, it's a little strong, but a underfunded trust is an empty promise. I didn't come up with that. Colleen probably came up with that.
I don't know.
Just a question concerning the special payments that have been made to many individuals during this pandemic in terms of stimulus check, enhanced unemployment check monies. Can you sort of go through which ones will have bad impact on government benefits, and how they could be sheltered, or where they should be kept, you know, if it's outside of a normal bank account?
And we do have time to deal with that, because it's not imperative that you move money right away, but ideally that's a wonderful, that money, and that's what I'm doing with my daughter's got the unemployment because she's not working right now. And I got a text from my wife, you need to move money from Kelsey's account because she has too much money. Now, I know I don't have to do that tomorrow, but ultimately I will move that into her ABLE account. And that way the money grows tax free, and it no longer is going to be an asset of hers that is deemed by Medicaid to be an available asset. You want to add anything to that, Colleen? Or?
No, I know for the stimulus, they have at least a year to spend that. I'm not sure about the unemployment. I haven't watched that as closely, but I know you have.
So does anybody have any other questions that they'd like to post on the chat?
I saw a quick one about divorce, and I just wanted to address it quickly. I often will have a divorced couple that have a child in common and they're both planning for them. They can do so with one special needs trust if they can agree on who the trustee will be, and if they can agree on who the residuary beneficiaries would be. So they can work together. I have a couple right now that's working together. They're going to have one special needs trust. They're both having their wills pour into that same special needs trust. Sometimes people can't agree on the trustee and the residual beneficiary, but if they can use one trust together.
Yeah. As long as parents can agree on who the trustee is going to be and who the ultimate beneficiary is going to be. So if they have more than one child and they're going to leave the remainder to their common child, then that's not a problem. But if there's a problem with who the trustee and who the remainder beneficiary is, then you're going to need two trusts. And I've dealt with families that are divorced and had meetings where each party came in separately at the same meeting, and then there was a joint meeting just to deal with the trust part, and then the new spouses and things were sandwiched around the meeting that specifically dealt with the trust.
A couple final questions or closing questions. If your child is getting SSDI and not SSI, can their assets exceed $1,600?
For Social Security, yes, but not for Medicaid. So that's why we always, if you're not receiving Medicaid benefits at all, SSDI is a non-means tested benefit. You can get SSDI if you had $1 million in the bank. It's based on your own work record, or this is a whole nother topic, child disability benefits, where once a parent either dies, becomes disabled, or even retires, turns on their own Social Security, then their child then receives Social Security will be 50% of the normal retirement age Social Security payment of the parent, or 75% when the parent passes. That is not means tested. Doesn't matter if you have money in your name. But Medicaid does get affected by that. So any benefits that DDS are providing, those are all Medicaid funded benefits. And if you have more than the 1,600, we have a problem.
What happens when both parents pass away and there's not a lot of money left to put into a special needs trust, and the special needs child is an only child? How can they live on what they get from SSI every month, and who cares for them?
So that's the $1 million question, right? And that's what the people at ARC are working so hard to help with. So you would want to start reaching out to resources long before the parents have passed away, and make sure that you can get on all the lists you can for housing and employment and anything else that you possibly can get involved in. There are other benefits. There's a benefit there's a cash benefit, there's a state supplement benefit. So there are a variety of other benefits that you can work with DDS or with, a benefits counselor to start to apply for and get enrolled in. But it's very difficult, and this is really what pulls at parents, right? So it's not a legal question or a financial question, but it's a parent answer, is that I would say, to the extent you can start building community as early as possible and start getting some resources in place, just like we talked about the supported decision-making, but for the parent maybe at this point, find their team of experts. It's going to take some planning. If there is no planning, ultimately the state will step in and make sure that that the child has a place to live. But it may not be what the parent had envisioned. So to the extent you can reach out and get support earlier, you're going to be more successful. I don't know if you want to add to that, Stuart, or Wynn. I mean, I think this is really a question for you.
For Wynn, that when you said you Wynn.
Stuart, you want to go first?
No, I don't have anything to add. It's, that is a tough question to answer, because it really depends on the functioning level of the individual.
Yeah.
Somebody who is very impaired, their needs are fairly taken care of. I mean, we at Plan have issues with spending money. Sometimes we have the opposite problem, where we look and we say, there's how much money is in here. What does a person need? Find out. Do they need a new TV, a computer, do they want to go anywhere? So it really depends on the individual. A higher functioning individual who may not qualify for group housing, that's more of a concern than somebody who could not live independently at all, and there's no choice but a supported living arrangement that typically is going to be funded by Medicaid dollars, the state.
Yeah, I would say that to this question, there is no one pathway to how that individual is going to live, and that it is completely a a question and an investigation and a plan that needs to come together well before the parents pass in terms of what are the strengths of that individual, and what are their interests, and how do they get along with other people. Just, all the attributes of the individual should be used in terms of guiding what that person's future looks like. Well, I think that we are out of questions.
And that was the perfect note to end on too, I think. That was exactly the right note. So I'm sorry to interrupt.
No, that's right. So I want to thank Colleen and Stuart very much for their participation tonight. I think that there have been numerous requests for the PowerPoint, and we'll see whether we can get that to people or not. The recording has all the PowerPoint slides on it, so that's useful, and the recording will get to all the participants tonight. So with that, thank you very much, and we'll look forward to our next meeting on whatever subject in probably about a month's time. Thank you and good night.
Take care.